Today, I will be summarizing the UK Supreme Court's landmark 2025 judgment in Standish versus Standish. This case has provided crucial clarity on one of the most contested issues in high net worth divorces, that is, the distinction between matrimonial and non-matrimonial property. It addresses the concept of matrimonialisation, the process by which non-matrimonial property can become matrimonial property subject to the sharing principle. So, what were the facts? The case involved a husband aged 72 and a wife aged 57 after a 15-year marriage. The total assets were valued at approximately 132 million British pounds, with the wife holding the majority of it. Now, crucially, more than half of this total assets was the husband's premarital wealth. The dispute centered on a single pivotal event. In 2017, about 3 years prior to their divorce, the husband transferred around £80 million worth of funds to the wife. The purpose of this transfer was explicit and well documented. It was for a tax planning strategy. The husband, a former investment banker, was concerned about becoming a UK tax resident and facing a potential inheritance tax liabilities of over £30 million. By transferring the assets to his wife, who was a non-domiciled resident, they could mitigate this tax exposure. The plan was for the wife to then place these assets into an offshore trust for the benefits of their 2 children. However, this never happened. The assets remained in her name, and when the marriage broke down in 2020, the central legal battle began. This led to the core legal question. Did the 2017 transfer convert the husband's non-matrimonial property into matrimonial property? In other words, has it been matrimonialised? The wife argued that it had. She contended that the transfer, coupled with the husband's alleged statement that what is mine is yours, demonstrated an intention to share the assets. Therefore, she claimed the entire £80 million was now part of the matrimonial pot and should be divided equally under the sharing principle. The husband countered that the transfer's sole purpose was tax planning, and it never changed the fundamental character of the assets. He argued that the source of the funds, that is his premarital wealth, was the determining factor, not the legal title. The Supreme Court unanimously dismissed the wife's appeal. It ruled decisively that the assets had not been matrimonialised. In doing so, the court reaffirmed 4 critical principles for family law practitioners. First, the sharing principle is limited to matrimonial property. It does not apply to non-matrimonial assets. However, non-matrimonial assets is still subject to the principles of needs and compensation. In layman terms, the fact that it is not matrimonial property is not the end of the story. Second, the source of an asset is more important than the legal title. Simply transferring an asset into a spouse's name does not automatically change its character. Third, matrimonialisation is not automatic. It requires evidence. The court must see proof that the parties, by their conduct, treated the assets as shared over time. A one-off transaction for a specific purpose is not enough. And in this particular case, transfer made for tax planning purposes is not sufficient to amount to matrimonialisation. Indeed, the court found that the husband's intention was to avoid tax, not to give the assets to the wife to be shared between them. The fact that the intended beneficiaries of the proposed trust were the children further weakened the wife's claim. So, what does this mean for us in Hong Kong? While the UK Supreme Court decisions are no longer binding, they remain highly persuasive. Hong Kong's own legal framework, established in the landmark case of DD versus LKW, already recognizes the distinction between matrimonial and non-matrimonial property, and the 3 principles of needs, compensation, and sharing. The The Standish judgment will likely be seen by Hong Kong courts as a compelling clarification of these principles. It reinforces the idea that the court must look beyond legal title to the source of an asset, the conduct and intention of the parties. We can expect Hong Kong courts to adopt a similar, strict approach when analyzing transfers between spouses, particularly when a clear, documented purpose exists. For our practice, this underscores the critical importance of advising clients on prenuptial agreements and the careful documentation of the parties' intention on dealing with their respective assets. In conclusion, Standish versus Standish provides a robust and clear framework for analyzing the matrimonialisation of assets. It champions substance over form, focusing on the source of wealth and the genuine intentions of the parties. For practitioners advising high net worth individuals, this decision is a vital tool for managing clients' expectations and structuring assets in a way that withstands judicial scrutiny.